All right, thanks, everybody. Michael Anzelmo, I'm an attorney here at Nelson Mullins, and I head up our Wills for Heroes program. Briefly, a little history on it. This program started after September 11th. We were looking for a way to help out our local first responders, and we figured this would be the best way. And it also worked out because a local Richland County deputy lost his life around the same time in the line of duty, didn't have a will, so the two things kind of came together, and this is what came out of it. We've been doing this program, like I said, since 2001. We've done many events here in Columbia. We've gone all around the state at this point for various events, partnering with clients or other law firms. And we also do it for the Wills for Vets program. It's the same program that we use in our Wills for Heroes, and I'm going to show you how it works. I'm going to move quickly, and you're going to think I'm not telling you enough, and I'm not, frankly. It's just not possible for me to teach everyone how to do a will in a brief period of time, and with the volume of clients that you're going to see that day, you do need to move them through somewhat quickly. To streamline that process, we have a questionnaire that each vet's going to receive, and what they do is fill out all the information that they need, and we limit the program to only certain types of bequests. They can't come in with very extravagant options and try to leave things. It's 4 basic disposition options, which I'm going to show you. In essence, it's a simple will, and the program is a fill-in-the-blank program mirrored off of the questionnaire, which I'm going to go through with you briefly. But the important thing to remember is that a lot of times these folks, like everyone, don't know anything about wills or what they actually even mean when they check the disposition option they want. I find sometimes what they check and what they tell you they want are not at all the same thing. So make sure you understand what your client wants, not what they think they want. I get the very common one of, I'm just going to leave everything to my sister, and when she dies, she knows who to give it to. And you have to explain to that person, well, your sister will get your property the day you die, and if she doesn't do what you want, tough, it's hers. And there's a lot of that. Well, my best friend is more than happy to take care of my kids. Well, you're going to put him as the guardian? Well, no. Well, that's sort of that's a disconnect, and you need to work through that. But by and large, these come in fairly simply. It's single folks who want to leave property to certain people, or it's married couples who want to leave it to the other spouse and then to their children. Those are 98% of what you're going to do. And the reason we train you on that basic scenario is if you get a weird scenario, I will be there, and other folks who do probate law will be there and can help you work through the problem. Can't train you on all the problems. It's just easier to flag me over, and we'll work through it right there with the client rather than go through it like that. Nora, did you hand out any of do they have a sample questionnaire? Okay. There's a little packet, Wills for Lawyers for Vets, training agenda. And you can see the first thing after the first greenish page is the questionnaire. The first thing, also a limitation on this, is the size of their estate. If these folks have estates excluding life insurance that exceeds $1 million, they really need to get a qualified, estate attorney to help them with their affairs for various reasons. So I like to start off by asking them if they think they have an estate that's in excess of $1 million, and you'll get the answer to that is yes a lot of times, especially when it's that people own a good bit of land. If it is, we're more than happy to give them a reference to or if you're qualified, if you're a real probate attorney or an estates attorney can handle it, please do. But we feel like we're not qualified for the tax implications of that. So we farm them out to folks who will give us a discounted rate. So keep that in mind. The second important question that I like to ask that is not on the questionnaire is if they have any special needs children. If they have special needs children, we cannot help them. They have to get certain trusts and things that take care of the federal benefits, and frankly, no one really knows how to do that except for a few folks in the South Carolina bar. If you're one of those people, please let us know, because we're always looking for people who can help do this, because no one seems to want to give a discount on this area of the law, because apparently it is quite burdensome on the attorney. But keep that in mind. We really cannot help them, but we will get them in touch with the person that they need to talk to. But as you can see, the questionnaire is rather straightforward. It asks your basic questions, such as your name, your spouse, the kids, I'll get back to the question about adopted children as we go through the will, where they live, who do you want to be the personal representative, guardians and custodians. As we see that, the parents will often put each other. That's just not necessary. Obviously, as a parent, you have full custody and parental rights over your child. This is the situation where neither parent is alive. They need to have a guardian and custodian take care of any minor children. They can name couples, they can name individuals, they can name them jointly. I mean, you'll see the language here. But a lot of them are also saying, well, I'm divorced and I don't want the ex to have anything to do with the kids. Sorry, wills don't address that. Take that up with the family court, and more or less good luck to you. And no, we won't add a clause in there saying that I don't want my ex to have custody. No, that just doesn't work. So you'll get that a lot. Work it through. They're pretty reasonable, but that's a big sticking point. It asks them, like I said, for the 4 dispositions, which are entire estate to your spouse, then to the children, grandchildren, that's sort of the family tree. The second option is all in trust for spouse equally to the children at the death of the spouse. This rarely comes up, so I rarely teach it. If you have somebody who thinks they want to do this, I think when I die, my ex is going to go back with their high school boyfriend or girlfriend, and I hate that person, and I don't want them to have the money. It happens. Just flag me down, and we'll see if they really want the trust set up. Because, again, their spouse doesn't actually inherit the property. It's just they get the benefits from the trust. It has to be managed by someone who's not the spouse. So if somebody wants to check the trust for spouse section, they should not name the spouse as the personal representative, because our personal representatives are our trustees in the will. So, again, if somebody uses that one, just let me know. It's happened maybe, 5 times in 10 years. It's just so infrequent, it's not worth talking about. Item 3, all to children equally. Obviously, this comes with the caveat of you can't cut your spouse out of your will. As y'all remember from law school, you have the omitted spouse, elective share, all that kind of stuff. So if they're trying to cut out a spouse, we have to counsel them. We can certainly put it in there, but if you omit a spouse, she is, or he is entitled to a minimum of a third recovery. Yeah. I think it comes from the fact that they think they get enough benefits. The spouse will have enough of their benefits of retirement or whatnot, and they don't want to provide for them. Again, they don't want to do the children. We're happy to do that, but again, it's just they're not going to be able to change the law. Option 4, same thing sort of comes into play if they're married, but this is the designated beneficiary. They can do it equally. They don't have to do it equally. If they want to leave, a house to somebody and the rest to somebody, we can do that. That's an easy fix that we can make. But those are the 4 disposition options. And if somebody wants something outside of that, then frankly they need to find an attorney who will do this for them. Otherwise, we'd never get people in and out. I mean, when we do these events, we have hundreds and hundreds of people we're trying to get through in a very brief period of time. So that's why we leave it where it is. What I'm going to do quickly and show you, we have a program which I know you'll never see again until the day of the program, but it is rather straightforward. Show you on the board. We'll go through, like I said, the entire estate contingent, to the spouse contingent to children, because that is by far the most popular option. And I'll work through some of the questions that come up as you go through it. We have frequently asked questions, and the healthcare power of attorney we'll hit briefly at the end. But one more thing before we jump into the will is you are going to get a representation agreement for them to sign, and we need you to sign that. That is the only thing that is kept at these events. These people leave with their wills. You're not keeping a copy. Obviously, there's nothing recorded until the person passes away. So that is the only record that we even performed anything for them, any services. It limits the representation to this will and nothing else. So we need to get that signed. And you probably should ask if they have any active litigation. We do. We don't really do a lot of family law, so if it's a divorce, it's not a big deal for our firm. But if, for instance, they're a plaintiff in a class action against a pharmaceutical manufacturer, we kind of need to know that to see if they're in the class action or are involved in it. If you have somebody who's involved in litigation, let us know. We'll do a quick, for our firm, we call it our conflicts department, but you can handle them how y'all need to handle them. Okay. All right. So it probably shouldn't be an issue, but I still like to know that. All right, so let's just jump into this thing. You'll get a computer that has a setup pretty much exactly like this. You'll see we have a nice little icon. It's called Wheels for Heroes. That's what you're going to be using. It will pop up, and you'll have all these things on the left side: South Carolina, healthcare power of attorney, living will, and simple will. We're going to go through the simple will, and then we're going to do healthcare powers of attorney. We don't do living wills through this program anymore. So if they have a healthcare power of attorney or they want one, that's what you'll be using. That is really straightforward there. All right, so after you hit the simple will, this box will pop up. Yes, you want to open it up. All right. You'll notice on this left side, this is when, as you work through it, these options will change. You'll see when it changes, but just keep in mind, you'll see changes. Don't be too worried about it. But for instance, you need to put the county, and I can't type. Yeah, it follows along with the questionnaire. I talked to them before, say, here's what a will does: nothing until you die. It protects assets, takes care of children once you pass away. Life insurance passes to the beneficiary in the life insurance form unless you have your estate as a beneficiary, which no one ever does. So if they need to make changes to their beneficiary, they need to do that on the life insurance policy itself, not here. And really, I said it's a simple document. Most people have one similar to this that has no effect until you pass away. They need to keep it somewhere safe. And if they want a copy, which I try to discourage for the obvious reason, keep it somewhere separate than the will. You'd be surprised how many people put the will and the copy in the same place, and the house burns down, and what's the good of the copy? So this thing will populate all the pronouns for you, so be sure to check the right one. And since we're doing me, I am a man. The city doesn't show up on the will, but you have to use it or you can't move to the next one. Then when you're ready to move to the next screen, you hit Next. All right, and then you have the questionnaire. At this point, you've talked to them about who they want to be. The personal representative needs to be 18 years of old as of today. So if they walk outside and get hit by the bus, you can't have a minor go to the court and probate this thing. So make sure that's in play. And no, it does not have to be somebody who lives in South Carolina. It just be somebody they trust, and that person should know where the will is being kept. That's really the extent of their role until our client passes away. So, of course, I'm married. I'm going to have my wife be my personal representative. Then I always recommend a successor personal representative because I'm hoping that all of their clients are going to live to be very old, and they're going to hopefully need a backup. Again, can be anybody. I'll obviously put the name, but put my dad. He lives in Louisiana. No problem there. Then you'll see the little options for the disposition. Like I said, the spouse to children is by far the most popular. If y'all have questions as we go through this, just yell at me. All you have to do is check the little box. And if you need to change it, it changes with you. Like I said, if you get all in the trust, just flag me or Nora down, and we'll talk it through. I think some people think they see the word trust and think it must be more fancy and more protections and help people out, and then you tell them what it does, and they're like, God, I don't want that. So just make sure they really, make sure what they select on their questionnaire really is what they want. All right, so the next box is down. The check to include the following are important. If they have children and they're minors, they are going to want to deal with the guardian issues that they set forth in their questionnaire. If you don't check that, you won't get to that screen. So make sure that is checked. The two underneath it relate to the all to designated beneficiaries option. So if you check that, then these two become active. If not, you can't do anything. Well, it doesn't do anything, but you can check them, but it doesn't do anything. Again, that's what I told you earlier. Yes, they can give stuff equally. Yes, they can give it in various portions. If they want to give to various portions, you go to more than one beneficiary, and you put what they want to get, okay, or what percentage they want to get. You'll notice once I checked into that beneficiaries box, the red thing, the deceased beneficiary children lit up. This is important. If they want to leave their house to their friend Tom and the rest of the stuff to their brother, whatever, John, and Tom dies, well, where does the house go? It'll probably default under the contingent to his closest living relative rather than Tom's, issue down the chain. So you have to explain to them, are you fine with just Tom, or do you want Tom or his kids to get it if Tom has passed away? And if the answer is yes, then you can check yes to the deceased beneficiary children. If he says no, you don't really need to check no, but you can. It'll take care of it by operational law. Again, that's one of those things that comes up less frequently than you think. So that's when you can always double check with me because I will be there that day. But that only comes into play again when they check designated beneficiaries and whether they want to leave it to that person's issue. We won't have that in this will because we're doing the spouse one. All right. So after you've done that screen, you'll see I checked the guardian because we have kids. We're going to hit next again. Okay, here we go. You got your guardians. And they can do primary only. Again, I like to tell them I like to have as much redundancy in the will as possible because you can't just simply write in somebody new to be your guardian in your will. You got to call somebody to get another will or a codicil or an amendment to the will. Basically, you're coming back to see another lawyer, and we're going to try to prevent that for you as much as possible. I mean, it's not always possible. So I try to push if they want to. Again, they're the client. They can tell us no. To do a primary and successor. Okay? So obviously, excuse me, my allergies are really doing well this week. It's just brutal. Yeah. So if you do that, primary, successor, we have some co-guardian language that we've added. I used to just do it the old-fashioned way of if I wanted Michael and Bonnie and Anzelmo to be the guardian, I'd ask the person, or the attorney would ask me, well, do you want them to do it jointly or individually? Meaning if Michael dies, are you fine with Bonnie or vice versa? And I just put and or if they said that didn't matter. We've gotten actual fancier language. So if they want co-guardians, a couple here and a couple there, you do need to ask them if they want them to act independently or unanimously. Obviously, those are self-explanatory terms, and they can tell you what they want them to do. That's rather easy to go through, but I'm going to put in some names here so we can just show you what it looks like. And then we'll make them act independently because that's probably the most common one. Oh, hang on. I forgot. Or I'm still not used to the new screen. All right. So if they do co-guardians, when you do this new fancy language, you actually put the first name in the first one, the second name in the second one. You don't do what I did earlier, which is my old default of the and. So you put the names in. Hit next. Okay, that's the end. Once you get through the children, that's the end of the will. This is the time you'll hit finish. Word will pop up slowly. Okay. Again, we're not saving anything. They're going to walk out of here with an executed will, not signed, notarized, the works, witnessed. So, no, we're not saving anything. That'll go away, and you'll end up with a will. I like to walk it through with them and explain each section. So I'm going to do that like I do with them. And again, it's quick. It's for a reason. We're moving them through. And frankly, I think most of the people who participate in these programs don't want the biggest, longest spiel about what a will is and what it does and all that. They just want to know that what they want is what they're getting. So again, this is me, my will. I always ask them to make sure I spell everything correctly because, again, I can't type and it's just easy to miss it. I explain to them that this is your will, and it says it's revoking any previous ones. If they have another one, they can go home and tear it up, throw it away, do whatever they want, because it is revoked, even though it's not really effective immediately. And if they don't have one, this is how all wills really should start, to tell the court this is my current will. First thing we do is appoint our personal representative and our backup personal representative. Lots of them who are reading this want to know what it means to serve without bond. I say that means the personal representative does not have to put up any sort of equivalent value or money for the value of your estate in order to go through the process. I frequently tell them if you don't trust somebody enough to do this for free, they really probably shouldn't be your personal representative. That's pretty true. But a lot of them ask what that means. I just like telling them. First thing that happens is that your debts and expenses are made arrangements for or taken care of. So the first thing the court's going to do is take care of that. That is rather straightforward. Usually by this point, I've told them you can't come back. You can't write on a will. I mean, I know this is a generalization, but most of the things we tell them are. You really can't write on a will. The first thing we want to tell them is, hey, look, there's an exception. Personal and household effects. We have a list here. It's really everything except property, bank accounts. The only thing that I can think of that actually we've done that isn't on that list are pets. Can be done. What it does is it tells the court, I might have a list of personal and household effects that I dispose of prior to the time you set my estate is. And we give them a handy-dandy starter list where they can list the item. The antique dining room hutch goes to Cousin Sally. I had a gentleman from the police department who had an antique gun collection of like 300 guns, and he came in with a list and wanted me to put it in the will. It's like, no chance. You're going to be in my office more than I'm going to be in my office when you fight with these people or they die. Use this list. You can do it anytime you want. You can change it. This is something they can tear up and handwrite a new one. I just say, make it look sort of like this one and be sufficient in your description of the item and who you want it to go to. I think most of them look at me like they're never going to use this, and I guarantee most of them did. So again, deaths and expenses, that stuff's taken out. What is left is your residuary in the estate. This is the standard language to leave something to your wife if she survives me. Obviously, if we had done it the other way, it'd be husband if he survives me. If not, equally among those of my children who have survived me with issue per stirpes, the good old-fashioned law school language that we all hated and trust in estates.
Go back on the personal effects. We had one, Susie and I had one just recently that a gentleman came in and he wanted his stuff to be donated to the church.
He wanted it to the church first, or a third to the church, and then to his two brothers and their wives.
Is personal property?
Or personal property. So we actually put the name of who he wanted it to go to in that.
Mhm.
He refused to list anything out. He said he wouldn't have anything left, but he just wanted it to go, the name of the groups and the individuals to go in that paragraph.
Yeah.
So they can change that to make it read that I want.
Yeah, I mean, they can. That's.
Effects to go to, instead of the personal representative, because that's how that reads,
Mhm.
is it would go to you.
Yeah, correct. That's a really weird way for that guy to do that because it's basically saying, I don't know what my personal belongings are going to be, but I want a third of it undefined. I mean, so we're going to have to do an inventory, and the court's going to, I mean, that's just, I mean, it's, but.
You said he lived in a topic and did not have the way of personal effects, and I think he thought he would have even less by the time he passed away.
Gotcha.
He wanted to give it to one brother, but not that brother's wife.
Gotcha.
It hadn't been very long enough.
Well, again, that's one of those situations where you're like, Michael, and we walk over there and we figure it out. I mean, you can't, yeah, you can't train for everything. All right, so
You can change that, just so they know.
yeah, you can change all these things, and I mean, this is a Word document. Y'all are attorneys, sophisticated people. If we need to change some stuff around, feel free. You're not locked into this language. Like, for instance, I almost always change the contingent disposition when they ask, because they ask me to. What I tell them, and we have not talked about this yet, is we try not to let your property just lapse over to the state, which is pretty hard to do. So our backup, the contingent disposition, is use the laws of the state of South Carolina, the intestacy laws, and I probably oversimplify this to them. It says find someone that I have a blood relation to. Single people, it'll start with your parents, and branch down through your brothers, sisters, nieces, nephews, that kind of thing. Most of them are fine with that. If you're married, it actually does the same thing through, if you don't have any kids left, it'll actually go to each of your respective sides, because we don't do joint wills. Those do exist. I do not know how to do them. If you do and you want to do one from scratch, I guess you can. We don't recommend it for this program. But if this wants to change, like for instance, they say, well, if the wife and my kids and grandkids and great-grandkids and all that have passed away and there's no one there, then I want to leave it to, Cousin Sally. Well, then what I do is I cheat. I just open up another will. I go to the thing where it said designated beneficiaries. I skip I just put in one letter for each thing, get that one to pop up, copy it, then I come in here and change it in the contingent disposition. No reason to reinvent the wheel. The only thing you need to do is you leave everything that I have not highlighted, because that lets the court know this is the contingent disposition, and then you change the stuff that's highlighted. So, for instance, if they want to change it to a certain person, then that's where you paste in the new language with the person or the church. We have a lot of people who say leave it to charity, and they'll give you the charity. This probably changes half the time. But if you want to help in changing it the first time, let me know. But again, like I said, you can draft the language yourself, or you can open up a new one and steal our language. That's what I do. It's just quicker. Definition of pars serpes. I mean, y'all can read this. This is still as incomprehensible to me as it was in law school. It's just a ridiculous paragraph. You know what it is. You die, we find a generational level where someone's alive, we stop and split. If there are multiple people in that generational level, the deceased person doesn't lose his or her interest. It passes down to that person's issue, if any. If there are no issues, then obviously that passes over to the other brother and sister, or whatever level it is. We have a chart we bring around to some events. I think we still have it. We started with husband, wife, kid, kid, kid. One of the kids has 2 grandkids, and we explain it that way. I usually kill off myself and the kid who has the grandkids, so you can show that 1/3 passes down to the 2 grandkids, and 1/6 shares equally. That's really, I mean, that's all they need to know, frankly, about pars serpes. I don't really know if you need to define that to them, other than just tell them it flows down the family tree and nobody gets cut out just because someone has died. But feel free to go in as much detail as you feel comfortable with on this section.
We have a chart.
Yeah, and we'll bring the chart, put it on an easel with the thing we did. And I'll go ahead and mark it up with the shares and everything, so you can just point to it if you want to. Fiduciary powers. Again, your personal representative is empowered more or less with a power of attorney type power to make sure that the terms of your will are carried out. If they need to, sell property, change bank account titles, do whatever they need to do to make sure that the beneficiaries get what they're supposed to be getting in conjunction with the court. We have not talked about the contingent trust yet, but this comes into play most of the time when the people have or planning to leave to children, or they have grandchildren in the family tree already. In this case, they probably do. That could take, if underage, if we have it at default as 21. Obviously, we create a trust so the children of the minor doesn't have to manage their financial affairs at 2 years old or whatnot. We have the personal representative as the trustee currently. That's just the default. Some people say, I'd rather it be my friend or my sister or whatever. You can just change that in Word. I mean, that's easy to do. Some of them say, I don't want this in there, just take it out. I try to advise them that's probably not the greatest idea ever, considering a 2-year-old can do nothing with, it's just, it's common sense. Most of them think it's a good idea. A lot of them want to move the age down. Some want to move it up. Again, it's a Word document, just change it around. I'd say 95% of them fine with just how it is. And again, that will only come into play if you check the children option or the person they plan to leave their estate to is under 21. Co-guardians, we've already done that. You can see where it populated me and my wife as co-guardians, and then this is the language about acting independently, may act independently without the consent of the other ones. And then we had the backup. There's my mom. There's Mom Anzelmo right there. So it populates for you, and it populates all the language. The other one just says must act, what's the one? Unanimously. And that's it. They often ask, what if they can't agree? Well, then there's going to be a petition of the family court or the probate court to decide who's going to win. Frankly, you're dead. You shouldn't care. That's it. The will ends on the signature. What we do is we have this thing set up in a way where you're going to be at a table or various tables with your client. Your role is going to be to get to this point, print out the will for them, and then they'll go to what we call, unfortunately, the execution squad.
We do it all.
Oh, we do? Oh, y'all do it all? Okay. Sorry. Well, when we have our bigger events, we have an execution squad. We send them over there, they sign, they notarize, and then we can get another person at our table. But since it's a smaller event, we're going to do it at the table. The will ends, number of pages. Like I said, it ends on your signature. 4 is the most common, but obviously if they don't have kids and it's one person, it'll likely be a 3-page will. Just pay attention to where the signature page actually falls. Have them add the day and the month, sign. You got your witnesses, add in their name, they'll sign, and your notary will fill in the notary jurat, and you're done. Again, I went through it quickly, but the main thing is going through that questionnaire with them and then making sure what they want is what they want, and then using this template to populate it. One thing I did not discuss, and we need to, is there's something on the questionnaire about adopted children and grandchildren. I'd say the vast majority of people leave this blank because they don't have adopted children or grandchildren. The reason it's in there is if you die with a will in South Carolina and you have an adopted child, that child is not treated as a blood child of yours, okay? If you die intestate, they are. Whatever. Might get complicated for us. So what I like to tell them is, again, we're trying to keep you from having to come back in and continually have your will revised. It takes time out of their schedule, and they're busy people, and we're busy. So we say if, maybe you're considering it down the road, maybe you're not considering it. We recommend that they check the box. Same thing with adopted grandchildren. They would not be included in the chain. And if they don't adopt or no one's adopted, it's no harm, no foul. It's in there, and it doesn't do anything. It might save them a trip. Someone would say, no, thank you. But I do tell them this. If they check the box and they have an adopted grandchild later in life and they don't want that child to take, they need to come back in and get a new will. So, again, just make that known to them that if they later adopt and they haven't selected this, they need to come back in and get a new will, because that child is not, it's not even excluded. It's just not even a child under the law. So that's an important thing right there to go through. And questions? I think the frequently asked questions, all that kind of stuff, are really the frequently asked questions in here. If you ever have questions, Nora or I are available in advance. Did you give them frequently asked questions? Well, if not, we can get them to you via email. Oh, yeah, they're the end. Frequently asked questions, I mean, that's really the thing. Separation. If someone is currently not divorced with an official divorce decree, that person is still in the will. If they get divorced after you have a will, you're divorced, it is as if that spouse predeceased you.
Are you doing any recommendations for uniform gift acts to minors?
We are not, and we probably need to start talking about that. We have not done that yet. If you feel comfortable talking about that, more than happy to let you do it, but it's just not something we do at this time. But again, if the person dies, a spouse divorce, as soon as that divorce decree is entered, it is if that spouse predeceased you. They don't have to come back in and get a new will. They can. But if they are just legally separated or the divorce proceedings have started, no, they are not divorced for the terms of the will. I really don't like that rule. So I will often tell if they're adamant they want to add some language about cutting the spouse out, if they walked out and got hit by the bus today, they don't want that person to do it. I'll add the language that says, I have filed for divorce. We are this, in the process, I am cutting this person out knowingly, voluntarily, intelligently, and just see where it falls, if it ever has to happen, there'll be litigation over it, but that's the one instance where I will add some language to the will to try to cut out a spouse. But I will tell them that if they reconcile, they need to come back in and get a new will. So that's really it for the wills. Like I said, 95, 98% of these things are very, very straightforward, and you won't have any questions, and you can get them out in minutes. Someone like me who's done God knows how many thousands, I probably honestly could push somebody out of here as quickly as I could type it up while explaining it. But take your time. Don't think you need to get through them. You'll have a smaller number of people, so you have the ability to spend more time with them. And like I said, I float around and will be able to answer any of the questions.
So the other thing that has come up was the same-sex marriage. And so we have changed it out to spouse, but actually we are requiring to see the marriage certificate
Right.
when they come in. So otherwise, make them a beneficiary.
That's what I've done in the past. I unknowingly actually did a will for some of a same-sex couple who's involved in part of the litigation about this. I didn't know until they filed the suit, and I went back like, that name is really familiar, and I actually did the will. And I can't believe I remembered it because I've done so many of these. That's right. If they are not actually married or they don't have a copy of the marriage license, because we do, just have them be named each other as the beneficiary in the will by name. I mean, they can designate them their spouse if they want to. That's just superfluous language, but just identify them by name, and that takes care of it. We're going to run through the healthcare power of attorney about as quickly as possible. I'm talking like 2 minutes. This, again, you hit the healthcare power of attorney in South Carolina. You hit OK. They're already going to have populated. And Nora, are we going to have these things pre-typed in, or is the attorney going to type in the information?
And the power of attorney information is also in the back of that questionnaire.
So the attorney's going to type in the info. Okay. Put in their information. I'm not going to, because I'm just flying through this to get to the new screen. Again, check the appropriate pronoun. You're going to get to the agent information, name, address, telephone number. In this day and age, really the cell phone is the most important thing. I actually tell the people to give your agents this document. Make a copy, give it to them. If you have a primary care doctor, some of them want it. Give it this to as many people as you can, because unlike a will, this thing's effective immediately, provided you can't make your own healthcare decisions. And if they, for instance, their agent moves, no, you don't need to come back in and get an attorney to change the address. If you feel like you absolutely have to, you can write the new address and just initial and date it. If any of the choices they make about their health treatment need to change, then they actually do need to come back in and at least do it in front of a notary or an attorney.
We have to explain what the agent is. Everybody's confused about what the agent is.
Yeah, this is the agent is the person that is going to make your healthcare decisions, provided you can't make your own, and you can either give them a lot of discretion or a very little amount of discretion on the choices that they select in the document that they come to. A lot of them have questions about what level this is, and that's why I want to show this to you. So I skipped all that. Also, don't save that. All right, unlike a will, this is actually rather self-explanatory. It's very layman's terms, probably because, as I joke, doctors have to read it. So they can read that themselves. This is where this stuff will populate about the agent, successor agent, and actually I think there is an option for a third agent as well. But the second agent. Unavailability, effective date, immediately, HIPAA authorization, agent powers. It's basically you become me to make medical decisions with the limitations that I'm about to impose on you, perhaps. E is infrequently used. The powers granted above do not include the following powers or are subject to the following rules or limitations. If somebody has something they don't want, like certain types of treatment for religious reasons or whatnot, this is where the section would go. I would find it odd that somebody, I think we've used this twice. I find it odd that somebody who would have those kind of things would delegate their healthcare decisions to someone anyway. That's why we don't see it a lot, I think. But if somebody wants to put something in here, flag me over and we'll make sure that's something that should fit. First thing's organ donation, and what we do is I tell them I am not judging any of these choices. I'm only here to give you advice on what, if you have questions about them. Frankly, it doesn't matter to me what you pick. I've seen it all. I think a lot of people are a little self-conscious about saying, no, I don't want organ donation or whatnot. So what I have them do is, after I've gone through this and typed in all the information on here, actually print the document out and then have them initial the blank of what they select with it.
I usually ask what's on their license too.
Yeah, and it can conflict. It can conflict, but most of them match up. And what I allow them to say is, well, right now I say I don't have it on my license. Well, this will say may, and this will control. If you have may not here, and you might want to get your license changed. 6 is something they can read. All right, first option is life-sustaining treatment. This is the mechanical means of keeping you alive other than nutrients, tube feeding, which is the next option. First one is summarized as grant of discretion of the agent. You can see what it says. I don't want it prolonged. What it is I'm delegating my decision to my agent. They need to talk to my doctor, get the diagnosis, prognosis, weigh the pros and cons, and then make a decision. I also tell them if they select this option, they really should have conversations with these people so there's some parameters for the agent. I mean, how that is enforced later, that's an issue. But the agent should have some knowledge of what your desires are, if that's going to be. A is a very popular selection, as is B. B is directed to withhold. It's I don't want to prolong my life, and I don't want treatment if I have a condition that's incurable and reversible, and I'll die in a relatively short period of time, or I will always be I'll be in a permanent state of unconsciousness. What I tell the folks, my clients, are, it says I will take the treatment if the doctor says this will. In 2 weeks, I'll pop out of this thing, but without having the respirator, I'm going to die. I'll take it. But I don't want to artificially prolong my life if I have either one of these two situations that come into play. A and B are the two most popular ones. Basically, give it to me if the doctor says it'll save me, but once it gets into A and B, pull the plug, basically. C speaks for itself. It is give me the maximum treatment possible for as long as I can have it. 8 is mirror image, just a little bit different language about tube feeding. I mean, they can plug you into a respirator or other machines to keep you alive. If they don't feed you, you're going to die. So these should be somewhat consistent, but they don't necessarily have to be. A is the same. as the first in 7. Talk to my doctor, see what the benefits are, see what the diagnosis is, and if you think it's a medically sound reason for me to do it, then give it to me. B is simply don't prolong my life with it. Again, if I'm in that 2-week state, yeah, I'll take it, or whatever period of time the doctor says it'll be a reasonable amount of time. Then give it to me. And then C is give it to me for as long as possible, as long as we got power at a hospital, basically. And that's it. They will sign it. Again, witness, notarized, done. I mean, really, I tell them, don't give wills out. Most people ignore me, but if you do, keep it somewhere safe. This one I'd give out everywhere. Give it to everybody on this thing, give it to your doctor. That's the easier one. They really just have questions about what the options really mean. The summary on the questionnaire is really a summary. It's like maximum, don't withhold it, grant of discretion. So they sometimes have some questions about the level of withholding. That's about it. We are working to get a presentation I did several years ago available to y'all. It's another training session where I go through this again. So if you feel like I went fast, which I did, and want to see it again, let us know, and we can probably make that available to you, either in a CD or a link. There were some technical snafus earlier. But it does exactly what I did here and go through another will. And I think we actually went through 2 different versions on that one, so you can see some other options. Questions? It really is a fun program, and it's rewarding, and it's not as scary as you think. When I started doing this, I mean, I'm not a trust and estates attorney, so I was petrified to take over the program and actually lead this thing. And you find that we call them simple wills because, frankly, they fit most people and they're easy to do because we have the language already for you. The weird ones, we just work it out, and if we don't feel comfortable doing it, I have friends we can call and then go over there and do it quickly for them, very, very cheap, or just tell us the language to use. So it is less scary than you think it will be.
And I'll say, I don't practice in that area at all, but I did the wills last session for the vets, and it's really, really easy. Very, very easy. So
Yep.
Very low income, most do not have spouses, but I found, so there is a lot of beneficiary language that you, some have come in and said, I want this piece of property to go here, and this one here, and this one here, and frankly, I'll just stop them in the very beginning before they even get to you and say, this is not a simple will, and we will refer you.
I disagree with Nora a little bit on that one. If they're giving out like 3 pieces of property, I'll just do that will, basically, because I've done it. That is my fear as well. A lot of them don't bring in legal descriptions of the property, okay? So I mean, look, Nora's right. We shouldn't do that because they don't bring in legal descriptions. Is our description going to be sufficient enough in the will to identify it with that actual legal description? There are issues. But if somebody brought in all their paperwork and we had it, I would be comfortable doing it. If you're not, that's cool. We have, like I said, we have people who will do this for $100, so that's not that big a deal. But well, frankly, we just stopped doing them. If you're comfortable doing them, I find that sometimes they can be a little inconsistent with what they pick in the healthcare power of attorney. I often caution them, say, just do one or the other, don't do both. And based on the needs of feedback we got from, we do a lot of this with the police departments, they would prefer the healthcare power of attorney, so we just limited it to that, more or less. Yeah, their familiarity. Yeah. Well, I won't take up any more of y'all's time, and like I said, if you have questions, you can call me, call Nora, and we can get you the link, or I can just answer them on the phone for you. Thanks, y'all.